Hi, my name is Caitlin Bailey, and this is my critical assignment presentation on legal issues in kinesiology. The facility that I chose to research for this semester was a college weight room. I selected this facility because I have aspirations of becoming a strength and conditioning coach at the collegiate level, and currently that's my position at the high school level. So I knew that research on this topic would be extremely valuable to me because it could apply to both my future and my current career. Legal issues surrounding this facility could involve the facility itself, including all the equipment it houses, barbells, dumbbells, kettlebells, quite an endless list. Could be the building that houses the actual facility, or people that come in and out of the weight room. That can include athletes, coaches of any sport that the college offers, strength and conditioning coaches, athletic trainers, or really any other employees of the athletic department. During this presentation, I will be discussing 6 legal cases that directly relate to my facility. The first 3 are going to focus on risk management, the process of identifying potential hazards and taking action to diminish the probability that injury or loss will occur. Now, given the physical nature of strength and conditioning training, as well as athletics in general, there will always be a certain amount of risk involved, but it is our job as managers to make sure that we are always looking for ways to mitigate these risks, to make sure that the facilities are as safe as possible for our athletes, our employees, and to reduce the liability of the school. The first case is Luan versus Chowan University from 2019. In this case, the plaintiff, Marco Luan, is claiming medical malpractice and negligence against the defendants after experiencing hyperthermia and heat stroke during a soccer practice. So in this case, Luan is claiming that the director of sports medicine, Lisa Bland, allowed a practice to go on during extreme weather conditions with a heat index of 105 degrees. Additionally, the plaintiff is claiming that the defendant failed to provide adequate medical assistance because the athletic trainer assigned to oversee the practice was not properly trained in handling heat-related illnesses. The defendant moved for summary judgment on the case, but following testimony, the court denied this motion and agreed that the defendant had failed to provide adequate medical assistance, and indeed the defendant's policies were negligent because the staff were not trained to handle the extreme heat conditions. Some strategies that could be employed to mitigate the risks involved in this case would be to implement heat index policies. So the New York State Public High School Athletic Association actually has a heat index policy that mandates a school abstain from all outdoor practice and activity when the heat index rises above 96 degrees Fahrenheit. So in this case, if Chowan University had employed this type of heat index policy, they wouldn't have even allowed to have this soccer practice happen outside, and Luan would not have even been exposed to these elements that resulted in his hypothermia and heat stroke. In addition, we should always make sure to train staff in emergency procedures. The National Association of Athletic Trainers provides a detailed treatment of heat illness with a step-by-step procedure for each degree of severity of heat-related illnesses. The next case is Vidal versus Levittown from 2017. In this case, we have the plaintiff, Alexa Vidal, who was injured from a falling barbell during a strength and conditioning workout that took place in the weight room. So she's claiming negligence due to dangerous conditions and improper supervision. So in this case, we have a strength and conditioning workout for a track and field team in which the plaintiff, Vidal, is about to take place in a bench press exercise. When a coach blows a whistle and gets all the athletes' attention, and then once he signifies it's time to resume the workout, another athlete on the track and field team bumps into the barbell and the barbell falls on top of Vidal, seriously injuring her. So in this case, the defendants moved for summary judgment, claiming that the plaintiff assumes the risk of injury during a workout and that adequate supervision was provided because there were 2 coaches for 25 athletes. This motion was denied by the court on the basis that the coach unreasonably increased the risk when he blew his whistle and distracted the athletes, and that the defendant's claim that the supervision was adequate was just merely their opinion. One of the claims brought up in this case was improper supervision. A strategy to mitigate this particular risk would be to implement a supervision policy. So the United Kingdom Athletics provides a coach's code of conduct that specifies a maximum ratio of 1 coach for every 12 athletes in order to provide optimal safety for the supervision of athletic activity. If Levittown had used this code of conduct, they would actually have violated it because they had 25 athletes for 2 coaches. So they would have been 1 athlete over the given maximum ratio. But it was always good to have these written policies so that you could refer back to them and say, this is our policy on supervision, and we did meet it. The last case involving risk management is Turk versus Town of Westboro from 2011. So in this case, we have our plaintiff, Alexander Turk, who's claiming negligence and willful, wanton, and reckless conduct against Westboro High School. So in this case, we have our plaintiff, Turk, who is performing a heavy squat, 400-pound squat, in the weight room when he trips over a floor mat and falls with the 400 pounds that he had on his back and incurs several serious injuries. In this case, the defendant moved for summary judgment, claiming that the uneven flooring was not the proximate cause of the plaintiff's injuries. However, after hearing testimony, the court denies the summary judgment on the negligence claim, but they do grant it for the claim of willful, wanton, and reckless conduct. So the case moves to trial, but only under the claim of negligence. A strategy to mitigate the risk involved in this case would be to implement and utilize safety checklists. There is countless equipment in a weight room, and it would be impossible to keep a mental account of how safe and up-to-date everything is. In addition, it would be wise to keep a written record to show, in a case like this, that you are, in fact, inspecting equipment on a regular basis and ensuring that everything is actually safe. The Fitness Training Academy provides a safety checklist for facilities that must be used by all trainers in their organization. These procedures include inspecting flooring surfaces daily and specifically mentions that mats should be arranged in a way that eliminates all tripping hazards. So that could be directly applied to this case. The next three cases will focus on issues of employment law. Employment law involves issues of relationships between people in the workplace, and that can include discrimination or unfair treatment as a result of race, gender, religion, age, or disability, sexual harassment, or violations of employers' duties to maintain a healthful and safe working environment. In the case of Moore versus the University of Notre Dame from 1998, our plaintiff, Joseph Moore, is claiming wrongful termination in violation of the Age Discrimination in Employment Act of 1967. Joseph Moore had been an assistant football coach for many years at the University of Notre Dame when his contract is not renewed, and he says it's solely because of his age. Now, he's 64 years old at the time. Now, the defendant is asserting that the termination was the result of substandard performance and abusive behaviors towards the athletes. However, during testimony, it comes out that the head coach at the time actually verbally told Moore that he could not be renewed for another 5-year contract because of his age. So given that evidence, the court asserts that the defendant violated the ADEA and that the plaintiff is entitled to front pay, attorney's fees, and costs. Now, in cases of wrongful termination, oftentimes reinstatement will be on the table. However, the court finds that this is not a viable option in this case because of the level of hostility that had risen between the plaintiff and the defendant over the course of litigation, and also because another third-party coach already occupied the position that Moore previously held. In addition, a jury verdict also awards back pay and damages because they find that the defendant acted willfully in their wrongful termination. Strategies to mitigate these employment issues could include establishing age-inclusive development programs. The Academy of Management suggests continuing education activities are vital for career competency of mid and late career employees. So this could include making available to all employees workshops, seminars, technology-based trainings, and tuition assistance programs for college courses, and making sure that their availability is effectively communicated to all employees regardless of their age. In addition, proper training for directors and supervisors could help mitigate these issues. Athletic directors especially, but even head coaches and administrators should be trained on the effects of age-related stereotypes, and they should be coached on how to only apply job-pertinent criteria to personnel decisions and employee treatment. In the case of Holcomb versus Iona College from 2008, our plaintiff, Craig Holcomb, claims wrongful termination and discrimination after he says he was fired from his position as an assistant basketball coach at Iona College solely on the basis that he was married to an African-American woman. Now, Iona College asserts that the termination stemmed from an overhaul of the basketball coaching staff, that the basketball team was underperforming at the time and they needed to overhaul the coaching staff. and they move for summary judgment. The court grants them summary judgment because they say that Holcomb failed to provide sufficient evidence to satisfy his claim. However, the case goes to the Court of Appeals, and they actually vacate the initial ruling of summary judgment because it comes to light that another assistant coach was also fired at the time. He himself is African American, and additionally, the third assistant coach was not terminated, and he was white. So the Court of Appeals determines that there is enough evidence to present to a jury, and they allow the case to go to trial. Strategies to mitigate the issues involved in this case could be a written declaration of commitment to diversity. The National Collegiate Athletic Association utilizes an inclusion statement to communicate their approach to achieving diversity. So this could be included in a athletic department's mission statement to clearly show their commitment to diversity and equal representation. Another strategy could be mandatory diversity training. So universities should ensure that administrators and members of their athletic department are attending diversity trainings and remaining educated on the fair treatment of protected classes. Some examples of this diversity training could be the NCAA's Inclusion Forum or their Sports Diversity and Inclusion Symposium. In the case of Pyrick versus IUPUI from 2007, our plaintiff, Debbie Pyrick, is the head coach for the women's tennis team, and she is claiming wrongful termination in violation of Title VII of the Civil Rights Act. So she is claiming that she was fired from her position as head coach of the women's tennis team solely because she is a woman, and that that female coaches are treated unfairly in her athletic department. The defendant asserts that the plaintiff was terminated due to unprofessional conduct, and they move for summary judgment. The court grants the summary judgment. However, following testimony is revealed that male coaches that actually have some NCAA violations and maybe other violations of conduct on their record are not fired from their positions as head coaches, and our plaintiff, who had no NCAA violations and no recorded record of unprofessional conduct, is fired, and so therefore she's treated unfairly. So the United States Court of Appeals reverses the summary judgment and remands the case for further proceedings. Strategies to mitigate the issues involved in this case could be developing an evaluation system for all employees. The Pennsylvania State Athletic Directors Association recommends having simple performance evaluation systems for all employees, and they recommend utilizing a numerical scale to score required skills and duties. Additionally, keeping performance records would be very helpful. The PSADA recommends a formal report and performance improvement plan, and that this is provided to all coaches biannually. And then this would help to document any unprofessional conduct or performance-related problems. After doing all this research, there are some key takeaways that I would like to apply to my future and current career. Providing proper training for staff is vital. As a manager, you could be fully aware of all the proper policies and procedures, but if your staff is not properly trained, that's going to pose a huge risk for you and for the school that you work for. Developing explicit policies to eliminate confusion and assumptions is very important. You might think some things are common sense, but if they're not written down, you cannot point to them in instances of litigation and say, these are our policies and we did or did not follow them. Enlisting the help of an external auditor could be helpful. I don't think it's fair to expect one person to be able to recognize all the possible risks, so bringing in an outside third party could be helpful. My biggest takeaway is that risk assessment and employment law considerations are ongoing. You can't just check the safety of something once and expect it to be fine forever. In addition, the cultural standards may evolve over time, and you might need to look at your employment law issues under a different lens. The first Bible verse from Galatians directly correlates to what the law says about discrimination and how we should treat our employees. The other two Bible verses I selected speak to justice and how legal precedents could be the never-failing stream of standards and information provided for us. Bringing our religious beliefs into our work has the potential to pose legal problems, much as it did in the case of Borden versus School District of Township of East Brunswick. However, I believe that we should never compromise our beliefs and morals, so if a work-related situation is legal but goes against your moral compass, maybe that particular work environment is not a good cultural fit.